So let's dive into this really fascinating legal puzzle. It's a rule of evidence that deals with a super tricky question, one that pits fairness against the search for truth. It's called similar fact evidence, and it's all about whether someone's past can or should be used against them in court today. And that brings us to the central dilemma, right? When is it actually fair for a court to look at what you've done before to judge what you're accused of doing now? I mean, is it genuinely helpful evidence, or does it just unfairly stack the deck against someone? This is the fundamental balancing act we're going to explore.
Okay, let's make this real. Imagine a company gets taken to court for a scam, and as you're digging into it, you find out they've pulled the exact same trick, step for step, on a whole bunch of other people. So the question is, should the judge be allowed to hear about those other cases? Does it prove they did it this time, or does it just paint them as a bad company in general? That's our core problem.
So what's the default setting in the legal world? Well, you might be surprised. The general rule, the place every court starts from, is actually to keep this kind of evidence out of the courtroom. That's right. The court's first instinct is to say, nope, we're not interested in what happened in other unrelated situations. The focus has to stay laser sharp on the facts of this specific case. But you gotta ask, why is that? Well, the reasoning is actually pretty smart. Courts are really worried about something they call a satellite inquiry. Just imagine if they let every past action in. A simple case could explode into a dozen mini-trials about things that happened years ago. It would get insanely expensive, take forever, and totally confuse the main issue. The actual case would just get lost in all that noise. And this whole idea was really solidified way back in 1858, in a classic case. And it wasn't some huge dramatic crime. It was a simple argument over the price of fertilizer. Yep. Guano, to be exact. So the buyer's argument was pretty straightforward. He said the seller was totally overcharging him, and he wanted to bring in other farmers to testify that they'd bought the exact same fertilizer for a lower price. I mean, that sounds perfectly reasonable, doesn't it? But the court said no way. The evidence was thrown out. Their logic? Just because the seller cut a different deal with someone else on a different day, that doesn't legally prove anything about the deal he made with this particular buyer. Each sale has to stand on its own 2 feet. And that case perfectly shows the default rule. Keep it out. But you know how the law is. It's never quite that simple. There's a really powerful exception to this rule, and this is where things get super interesting. Which leads to this critical question. What if the past behavior isn't just kind of similar, but it's part of a distinct, almost identical pattern? What if it's so unique that it's basically the person's calling card? Right, so for this kind of evidence to get in, it has to do a lot more than just show someone has a tendency to do something. It has to prove something incredibly specific. For instance, it could show a consistent business model for committing fraud. Or it could prove that something that looks like an accident was almost certainly not a coincidence, like if the same person has had 5 other accidental fires at their businesses. It can even be used to show a specific state of mind, like proving they had the intent to defraud someone. A perfect example of this is the case of Joy versus Phillips. Here, a company was being sued for a deceptive sales pitch, and the court allowed evidence that they used the exact same misleading script, word for word, on a whole bunch of other customers. See, that's not just a coincidence anymore. That's proof of a deliberate system. That is a signature. And this right here gets us to the absolute core of this whole thing, the critical difference between proving a pattern of behavior and just, attacking someone's personality. And this isn't some minor legal detail. It's a foundation of our entire system of justice. So look, this distinction is everything. Character evidence basically argues he did it because he's a dishonest person. The law almost always rejects that because our system is built on judging people for what they do, not for who we think they are. But similar fact evidence argues something very different. It says he likely did it because his past actions show a uniquely specific pattern of doing this exact thing. It's not about personality, it's about the pattern. Let's break this down even more. For character evidence, the focus is super general. It's about their disposition, who they are. For similar fact evidence, it's super specific. It's about their conduct, what they've done. The whole purpose of character evidence is to just suggest they're that type of person, which legally is a pretty weak argument. But the purpose of similar fact evidence is to prove a unique system, a signature, which is a very powerful argument. And that's exactly why one is almost always inadmissible, while the other can get in if it's relevant enough.
The example says it all, right? The defendant is a known liar versus the defendant used this exact fraudulent template 3 other times. You can just feel the massive difference in evidentiary power.
This leads us to a phrase you've probably heard a million times on crime shows: modus operandi. It's just Latin for method of operation. And that's exactly what similar fact evidence is trying to prove. Not that someone has a bad character, but that they have a specific, repeatable, and unique method for doing something. It's their signature. Okay, so how does this legal principle, which got its start with fertilizer disputes in the 1800s, actually applied here in the 21st century? Well, the challenges are evolving, especially in our digital world, and legal systems everywhere, like in Sierra Leone, are having to adapt. Modern legal reforms like Sierra Leone's Criminal Procedure Act of 2024 are really raising the bar for what counts as good evidence. And even though it's a criminal law, its sophisticated, modern approach to evidence is creating a ripple effect, and it's starting to influence how civil courts think about things like digital patterns. So, what does a modern modus operandi even look like? We're not talking about a handwritten script anymore. Today's signature could be the repeated use of a specific IP address in cyber fraud cases or a particular piece of code used over and over in phishing emails. These digital footprints, these are the signatures of the 21st century. And to keep things fair, there's been a big procedural shift. To stop one side from suddenly ambushing the other in the middle of a trial with all this evidence of past actions, something called a trial by ambush, judges now often decide whether to allow this kind of evidence way ahead of time at a pre-trial conference. It just ensures everyone knows the rules of the game before it starts.
So how does a judge actually make this tough call? It's not a gut feeling. It really boils down to a clear, logical checklist. The judge's job is to act as a gatekeeper for fairness. It's basically a 4-step test. First, they categorize it. Are we talking about someone's general reputation or a specific act? If it's a specific act, they move to step 2, relevance. Does it actually show a unique system or signature? Then proximity. Did this happen last week or 30 years ago? If it's too old or too different, it's probably out. And finally, the big one, the justice test. Even if it's relevant, is letting it in going to derail the entire trial and create a confusing trial within a trial? It is a constant, careful balancing act. And this really just hammers home the judge's role. They are the gatekeeper. Their most important job here is to make sure that this really powerful tool is used to uncover the truth about a specific pattern and not just used as a sneaky backdoor to trash someone's character. And that leaves us with one final thought. The law is in his constant tug of war, trying to balance an individual's right to a fair trial with the court's mission to find the truth. In an age where every single one of us leaves a permanent, searchable digital footprint, do you think the law is getting that balance right? It's definitely something to think about.